Hello, and thank you for joining us today for this Edward Jones webinar, Estate Planning, Securing Your Family's Future. My name is Sandy Miller. Before we get going, let me highlight a few of the features on your screen that we're going to be using. On your screen right now, you should already see a video window with me inside. There should be another window with our presentation slides and a third window for our Q&A feature. If for some reason you have any difficulty during the program, you can click on the Help icon at the bottom of your screen. That's the black question mark inside the yellow circle. This is for any technical questions you may have. We also have a team on standby ready to assist you if at any time during our discussion you have a question or would like clarification on a point. Just click on the Q&A icon, which is the third button from the left at the bottom of your screen. That will allow you to send in your questions. We will do our best to answer your questions in the allotted time we're given. If your question is not answered, please follow up with your Edward Jones financial advisor. If you do not have an Edward Jones financial advisor, please click on the Find an FA widget below. We also have a lot of helpful resources and information available for you inside the Resources icon, which is located next to the Q&A icon. All right, now that you know your way around, let's get started. Protection can take many forms, and one way to protect yourself and your family is to undertake estate planning, which can help prevent uncertainty by minimizing conflict and confusion during high stress and emotional times. Joining us today are two members of our Client Needs Research team in our home office, Senior Analyst Elizabeth Anderson and Senior Strategist Amy Tyson, as well as Edward Jones Financial Advisor Charles Richards. Thank you all for being here today. We appreciate it. Amy, I'm going to start with you. There's much more to estate planning than simply designating where your assets go upon your passing. There are also a couple of myths surrounding estate planning, and those are that estate planning is for people with a lot of money. The second myth is that if you have a will, that's all you need. But that's not the case.
Sandy, as you said, estate planning involves much more than simply deciding which assets should go to your beneficiaries upon your death. An estate strategy can help you have confidence that someone knows your wishes and can carry them out during your life and after your passing. Putting a comprehensive estate plan in place can assist you in transferring your assets according to your preferences, appointing someone to make decisions on your behalf if you are unable to do so, and also providing a way to take care of the people and causes that are most important to you. Having an estate strategy in place helps you ensure that your wishes are followed in a structured manner, reducing potential delays and conflicts that could arise.
If these plans haven't been put in place, what can happen?
Well, that really depends, Sandy. Regarding asset transfers, titling is very important. Some assets pass by joint ownership, others pass by beneficiary designations. If you haven't chosen a beneficiary, some assets, such as your Edward Jones retirement accounts, would pass to the default beneficiaries outlined in our account agreement. Other individually owned assets might pass according to state laws. Unfortunately, every state law could be different, and they're going to dictate how those assets will be passed after a person's death, and those transfers will be provided based on those statutes. The statutes will also have laws about how to handle decisions during incapacity and how to select guardians for minor children. If you haven't made those arrangements, the state laws will apply, and they might not align with your wishes.
When we think of estate planning, most often we think about wills. How can a will help you protect your family?
Wills are really the cornerstone of basic estate planning. Beyond dictating your wishes for how to transfer your assets, they provide you with the opportunity to appoint guardians for your minor children. You can choose not only who you want to be the custodian of your children, that's the person who lives with them and makes daily decisions for them, but you can also choose who you want to be in charge of any assets that you might be leaving for those minor children. The day-to-day custodian doesn't have to be the same person as the one handling the money, but it could be. Your will could also set forth rules for how and why the money can be used for your kids. You may also have an opportunity to leave a letter sharing what's most important to you for your children, for how they're raised, perhaps about their education, their employment, their allowance, etc. And there may be other opportunities to note your preferences regarding how to divide your personal assets among your loved ones. That might include items such as jewelry, art, furniture, or other keepsakes. That note could also share your wishes regarding the handling of your funeral or your remains. You should discuss how to best share your requests with your attorney to make sure they're all properly documented. And if you're in a situation where you're serving as guardian of an adult child, perhaps one with special needs, you'll want to seek specialized legal advice to make sure that the care and guardianship of that child is properly handled in your estate planning. This can avoid any interruptions in their care should you be unable to continue to serve as their guardian or upon your death. Because Edward Jones, its employees, and its financial advisors can't provide tax or legal advice, it's recommended that you have a team approach when it comes to planning your estate. The team would be comprised of your financial advisor, your estate planning attorney, and your tax professional. That's going to help ensure that your unique situation is addressed.
You just mentioned working with an estate planning attorney. Now, I think most of us understand that we go to a lawyer to do estate planning, but what can we expect to walk away with when we leave their office?
As Elizabeth mentioned, as well as the basic estate planning document, your lawyer might also create a revocable trust for you. A revocable trust is another tool to assist with incapacity planning as well as asset transfer. But there are a few other foundational estate planning documents beyond wills and trust that are standard in an estate planning package. These documents can play a tremendously important role during your life to make sure you're protecting yourself and your family to the greatest extent possible. The exact names might differ, from state to state, but generally they are a financial power of attorney, a healthcare power of attorney, and a living will healthcare directive. We're going to go deeper into what each of those documents does, but before we dive into more detail, I'd like to ask you all a few questions to consider by yourself to reflect on where you might be setting up your estate to protect yourself and your family. Do you know whether you and your family have any of these three documents, the powers of attorney or healthcare directive? If you think that you have any of those, do you know where they are located? Can they be easily accessed? Do you know who you've appointed to serve as your agent under your financial and healthcare powers? How about as guardian of any minor children? If you can recall who you've appointed, are those still who you would choose if you were deciding today? And finally, have you shared your appointments with those individuals you've chosen? With your answers in mind, we're going to dig a little deeper into what these documents do so that by the end of this webinar, you either feel confident in what you have in place or you are better prepared to work with your lawyer to get these documents completed.
Charles, thank you. I think that gives us all a bit to think about. Let's say that I haven't executed any powers of attorney or I don't recall what they are. Amy, can you explain more about what a financial power of attorney is?
Sandy, of course. A financial power of attorney allows you to appoint an agent to act on your behalf with regard to financial and other legal decisions. You can name an individual. You can name multiple individuals in a succession of individuals in the event that someone cannot serve. A power of attorney document dictates exactly what powers you are granting your agents. Many financial POAs grant standard powers that were created by your state, which allow your agents to do things such as write checks, withdraw funds, and make trades in a brokerage account. But you can also limit those powers or even provide for special powers. Your lawyer can walk you through what exactly those powers might be and what you might want to think through. Before executing a power of attorney, there are also a few terms that are often associated with POAs that will be very helpful for you to understand. The first term that I want to talk about is durable, meaning it will continue regardless of your incapacitation. Your POA doesn't have to be durable though. You could choose to have it terminate at some point other than your death, depending on your preferences. You could also choose to have a power of attorney that is called springing. A springing power of attorney grants your agent the power upon a certain condition being met. A common springing power is becoming effective after the determination of incapacity. If you opt for a springing power, it is beneficial to really understand what that means. Oftentimes, there are certain conditions that need to be met. You might need a note from 2 doctors, or you might even need a court order with that determination. Your lawyer can also help you determine if the springing power might be appropriate for your situation.
Yeah, about 4 years ago, we assisted 2 of our clients, a son and his elderly mother, who used a springing POA. The mother had been in a nursing home for quite some time, and the family was starting to realize that her mental capacity was diminishing. Thankfully, they were able to execute the springing POA while she was still of sound mind. So by the time her condition had deteriorated even further, everything was in place to allow her son to handle her financial affairs, which he still handles today. I believe it's important to be proactive and not wait until it's too late.
And how does a healthcare power of attorney differ from a financial power of attorney?
While a financial power of attorney is usually related to financial or perhaps legal matters, a healthcare power of attorney appoints an agent to make all of your medical decisions. Like financial powers of attorney, you can appoint 1 or several people to serve as your agent. You can also have the option of providing a list of successor agents should someone be unable to serve. Your agent will rely upon their understanding of your wishes or any written directives that you might have to make healthcare decisions when you're unable to do so.
Yeah. When partnering with estate planning attorneys to serve our clients, it's been my experience that they always include a healthcare POA when creating or updating an estate plan. They have a lot of insight and will ask our clients to consider many of the what ifs and to think 2, 3, or even 4 people down the line as far as who will serve as their agent.
Elizabeth, you mentioned written directives, a term Charles used earlier. Would you mind explaining that concept a bit more?
Sure. The third document that Charles mentioned was alternatively called a living will or healthcare directive. There are actually plenty of different names for this document. For example, sometimes it's called an advance directive. And to be perfectly honest, sometimes the information that we're talking about right now is actually incorporated within the healthcare power of attorney. So it's not a separate document at all. But essentially, what we're talking about is a written document that expresses your preferences regarding healthcare. It's where you might share your wishes about things like end-of-life care or palliative care. Documenting your preferences can really help your decision maker to make difficult decisions. Decisions like withholding care or removing life support. And it also ensures that your wishes are carried out when the time comes.
We've discussed appointing individuals to some pretty important roles, guardian of our children, agents to take care of our assets, and even someone who will make sure our passing goes the way we want it to. Charles, how does someone choose who to appoint to these positions?
Well, I'm sure many of us have seen someone default to just naming their children in order of birth. And while that might work well for you, I encourage you to put a bit more thought into your choice. To start, you might want to consider who you don't necessarily have to appoint: your spouse, your parents, or even your children. Maybe it's a friend or even a professional such as an attorney, CPA, or professional fiduciary who is going to be right for you. Your appointed individuals serve an incredibly important role in your life. So take some time to think about who might be best, not only at the moment, but down the line. Here are some questions you might want to ask yourself. Who has the best ability to serve on my behalf? Who is accessible? Who has deep knowledge of me and my preferences? Who has the aptitude to carry out what needs to be done? Who is willing to serve? Who will undertake what needs to get done and is willing to respect my wishes in doing so? And while it's been mentioned a few times, it's good to have a line of successors named if possible. Naming successors allows you the freedom of not having to update your documents if something happens with one of your appointed individuals, and provides for contingencies in case you are unable to update the plan at a later date.
Like everything in life, things can change. Is executing an estate plan somewhat of a one and done process, or are there opportunities to review and change your plan over time?
Sandy, estate planning can be an uncomfortable topic for many people, so it's not uncommon to take the one and done approach. But remember, reviewing your documents periodically to ensure they're in line with your wishes is just as important as setting them up. Estate laws, as well as changes to your personal situation, such as even moving to another state, can affect how your assets will be distributed. A good practice is to review your estate plan every 3 to 5 years, or when you do have a life change. Your financial advisor will meet with you annually. They will review your goals, they will see what changes have been made, and they can also review your accounts at Edward Jones.
And while it can be an uncomfortable subject, it's important to share your plans with your family, correct?
Sharing your plan and the rationale behind your plan is a powerful way to pass on your values, your purpose, and your vision for your legacy. Although we recommend sharing an estate plan with your beneficiaries, there are options of how much you might want to communicate. You can share the contents of your plan at a very high level. You might be comfortable sharing specific dollar amounts, their estimated value, or you might just want to focus on your personal thoughts about wealth creation. Ultimately, you're in control of how much information to share. With that in mind, it is essential, though, to communicate at a minimum roles and responsibilities to those you have named in a fiduciary capacity in your document, such as your executor and trustee. It is important for those individuals to be comfortable and prepared for the duties that you have asked them to perform. The need to access estate and medical directives and incapacity planning documents often occurs suddenly. Communication of the location of those documents and how to access them keeps them from guessing while grieving or during a very stressful time. If you're interested in starting to have this communication with your family and having a family meeting, your FA can help you facilitate that meeting. Establishing an estate plan and helping to communicate all of your wishes, your legacy and purpose and values is very powerful.
Unfortunately, we had a prospect call our branch a few years ago following the passing of her father. She and other members of her family were under a lot of stress because they knew her father had a will, but they could not find it. While it is a personal decision to share the documents of your estate plan, there are many benefits to discussing your wishes prior to death. This is your legacy. Sharing some or all of the details of your estate plan allows you to tell your story rather than putting the burden of guesswork on your heirs.
Good information. Any final thoughts today? Elizabeth, I'll start with you.
Final key part of the planning process that's often neglected, and I've seen it all too often throughout my career, are the steps in the execution of the documents. Once you receive your final estate planning documents, work with your attorney to ensure that everything's properly signed. Also, it's not uncommon for your plan to require additional administrative paperwork, such as updating your beneficiaries or retitling some of your assets or accounts. Your financial advisor can work with you to make any suggested changes to your Edward Jones accounts. Make sure you don't skip any steps in the process. And if you're unsure of any aspect related to the execution, please clarify it with your estate planning attorney.
You've worked many years to build your legacy, and you've partnered with trusted advisors to craft your plan. Make sure to take the process to the finish line, and don't forget to review it periodically to keep it current.
Thank you all so much for your time today and for sharing your knowledge and insight. As I mentioned earlier, we have several resources that we hope will help you during this time. Be sure to check them out by going to the resource icon on your screen. We're now going to start the Q&A portion of the program. We have a team of subject matter experts waiting online to answer your questions through the Q&A widget. Please remember that there will not be any video during this portion. You will only see a slide prompting you that the Q&A is now in session. Rest assured, the webinar is still live. We'll do our best to answer your questions during the allotted time. If your question is not answered, please follow up with your Edward Jones financial advisor. If you don't have an Edward Jones financial advisor, please click on the Find an FA widget below. I also want to remind you that this broadcast will be available again on demand using the same link you used to register for today's program. Please note our upcoming webinar as well. Thanks again for joining us, and please enjoy the rest of your day.
you.